My name is Regina Palmer Coleman, and I'm going to talk to you today about how to determine when the date of injury occurs in a workers' comp case. Now, generally, an injured worker receives benefits from a compensable injury. Now, a compensable injury is any injury to the physical structure of an employee's body during the course and scope of their employment. Now, an employer's insurance company will try to bring up an affirmative defense and state that there was an untimely notice of the compensable injury. And that is where the date of injury issue occurs. Now, generally, even if there is a compensable injury, as in the employee was injured during the course and scope of their employment, the employer's insurance can be relieved of paying for the benefits if it is shown that the employee failed to give notice to a supervisor or employer of the injury within 30 days of the date of injury. Now, this 30-day rule really is important when it comes to compensability issues. So generally, there are two types of dates in which a date of injury may occur. The first is a specific instance, and that is when an employee is injured, such as hitting their knee on a piece of equipment or falling, or some type of injury that from its nature is very obvious that it's work-related. Now, with those type of injuries, the employee must tell the supervisor or employer within 30 days. Now, the second type of injury is a little bit more, it's not as clear. It's called occupational disease. Now, that type of injury occurs when there is some type of repetitive action, such as having to move back and forth every day for 5 or 6 years, or it could be something to the effect of a lung disease, something where you've inhaled some kind of chemical for a certain amount of time that resulted in some kind of illness, or it could be something as simple as carpal tunnel syndrome, where you're moving your wrist a lot and that type of repetitive action caused the injury. Now, in order to prove that, you need to show that this chronic illness was related to your work or occupational duties. Now, the standard for an occupational disease type of injury is a little bit different than a specific instance. Now, the 30-day rule doesn't start until the employee knew or should have known that this illness or disease may be related to a work-related duty that the employee has to fulfill. Now, with this, you have to be able to distinguish between an occupational disease, something that was the result of your work-related duties, and a ordinary disease, which is just something that naturally would have occurred regardless of what type of work you do. So again, when you're thinking about your workers' comp and thinking about bringing that claim, you have to be cognizant and aware of this 30-day rule. So if you have a specific instance where you hit your knee, you have 30 days to report it to your employer. If it's something that has progressively occurred that was a result of something work-related, then you have 30 days after the date in which you have come to the realization that it's something work-related to tell your employer. Lastly, just a couple miscellaneous things that you have to know. This 30-day rule is a hard rule. Even if your employer requires you to report your incident in 15 days, that does not have anything to do with the rule that is within the workers' comp code. You have 30 days to report it, regardless of whatever your employee-employer handbook states. And you must give notice for any type of subsequent injury or aggravation, even if your employer already knows about the previous injury. Keeping your employer up to date on your injuries and things that happen during your course and scope of employment will ensure that your worker comp case will be that much more successful. Thank you.